Good morning, everyone, and a very warm welcome to you all. Thank you for joining this webinar, which is the second in a series of short 30-minute webinars that we're running over the next few weeks, exploring a number of themes on whistleblowing. The next one, should you like to register for it, is next Thursday at 11 AM UK, where we'll be talking about choosing and implementing a whistleblowing system. In the first session last week, we discussed the EU Whistleblowing Directive and its specific impact on UK companies, now that we're no longer a member of the EU. This week, we're staying with the directive, but we're looking at it from a broader context and exploring in more detail the requirements for compliance. Without taking up too much time, let me start with some brief introductions. My name's Andrew Breakwell. I'm Commercial Director for EQS Group in the UK, where we provide a range of digital compliance solutions to a range of organizations, including our Integrity Line whistleblowing system. I'm pleased to be joined today by one of my colleagues from Germany, Jens Gressler, who works on EQS Group's integrated platform for corporate compliance. And within EQS, Jens is the central point of contact around the EU Whistleblowing Directive and its transposition into legislation within individual member states. So he's been tracking the legislation and the directive very closely. So Jens, good morning. Thanks for joining us. Although we've got a relatively short amount of time today, we'd really welcome your participation. So we've allowed time towards the end of this session to address any questions you may have. Just one caveat around the questions: we're not legal professionals or experts, so we'll answer the questions based on our knowledge and experience of this sector and the directive, but not it shouldn't be relied upon for legal advice. As any questions or comments come to mind, please enter them into the panel at the bottom of the screen. We'll get to as many of them as possible after the main discussion. You'll also see some of the other functions available to you on this webinar platform on the screen in front of you. So yeah, Jens, let's kick off. I'd like to start by asking you to just go through the directive, provide a high-level overview of the directive and the requirements it imposes on companies.
Yeah, thank you very much, Andy. Pleasure to be here and to provide to this webinar. So I had the pleasure to also speak last week, and last week we've been addressing the directive itself and addressing the question who is affected, UK companies with legal entities within the EU member states, and vice versa. So we shed some light on this. It was maybe rather the higher level perspective. And today we actually want to take a closer look at the requirements, and especially the core requirements that the EU directive is bringing into the game, and that might affect you and the organizations and companies you work for. So before we look at this in more detail, I would just like to remind all of us a little bit about what the EU directive is actually about, and what is it trying to achieve, so that we are all aligned here. So basically, the EU directive is looking at providing good protection to potential whistleblowers that speak up and report on misconduct or breaches of especially EU law and regulations. So this is clearly the main scope of the directive, establishing kind of a speak up culture and mechanism across the member states, and addressing EU legislation as a base. In the context of the transposition into national legislation by the member states, there is some, let's say, some open doors the member states can choose to go through, and by enhancing the defined minimum standard of the directive. And this clearly is related to the type of reporting channels that should be established it also allows the member states to, for example, choose to enhance the scope beyond EU legislation and say, for example, in Portugal, also any breaches of Portuguese legislation can be reported on, right? So this is an opening factor. There is some options around anonymous reporting. There are some options around which public channels will be offered and which responsible authorities will be named within the countries. And there is also an option to decide, and we are seeing this because I already mentioned Portugal. We are seeing this in Portugal, one of the 5 countries that transposed until today, that they are immediately starting with any company larger than 50 employees by the middle of 2022. So they have decided to shorten the transition period that the directive brings with it, which would mean that organizations with more than 250 people are obliged since 17th of December 2021, and the ones larger than 50 would only be mandatory from December 2023 on. So Portugal has decided to move this forward and include everyone larger than 50, and France actually is currently doing the same, right? So as you see, there's a directive defining some minimum standards that go beyond what many of the member states had in terms of legislation before, but some options are available. So let's take a look at the requirements. What does the directive require you as a company, as an organization to do? The first requirement is clearly that you need to establish internal reporting channels, or an internal reporting channel that would allow any person, any stakeholder, that might be an employee, but that might also be other stakeholders around your organization, to speak up and report to you on the breaches of legislation that I spoke about earlier. And if you as an organization decide to do so, you could even allow and include misconduct regarding your code of ethics or code of conduct or whatever you have in place, or any other policies. So you're free to include this into your reporting channels. So this reporting channel, what does it need to be? Does it need to be a call center? Does it need to be a web-based solution? Does it need to be an email address that you publish? This is something that is not 100% precisely described in the directive, but if you interpret some of the other requirements the directive is talking about, then it becomes quite clear that that certain requirements are related to this channel. So the reporting channel you're offering would need to allow either written or verbal reporting to the organization. And verbal reporting would mean that you could even consider to just allow or offer a phone number with kind of an recording mechanism, so a technical phone solution, but you would not be obliged to engage a call center, for example, to handle this. On the other hand, the directive is saying it's all about the confidentiality of the whistleblower. So the identity needs to be protected by all means, and this includes also technical means. And the requirement is actually saying that you need to make sure that only the person that has been appointed by the organization, or the person or persons, so to handle and to manage the reporting channel, can have access to the report and all the information included. So it's all about security of the information, security of this highly sensitive information. And having said this indirectly excludes things like, for example, an email address. Because usually an email address would be part of your IT infrastructure. It would be handled by your IT administrators. It's probably not encrypted, so the information might be accessible. And so from this perspective, just offering an email address and say, this is our reporting channel, will most likely not be sufficient. And there's good reasons, and clearly, yes, we at EQS Group, we are a provider of web-based and phone-based reporting channels, but there's good reason for safeguarding the identity of the whistleblower and protecting it. Because there's a lot of disadvantages whistleblowers have been facing. And so since many, many years, we've been dealing with exactly this, right? Reporting channels that can be highly secure, protecting the whistleblower, while at the same time allowing the organization to communicate with confidential or even anonymous whistleblowers in a secure way, storing the data in a secure place, complying with GDPR requirements, and so on. So the web-based channels that are offered by providers like us are clearly a good alternative or a good option to comply, and at the same time you could they are very flexible, so they would allow written reporting in writing, as well as verbally by calling a phone number and then taking the spoken report into the same highly secure application. Okay, so internal reporting channels is one of the requirements, and ideally addressed by a secure technical solution maintained and operated by an external service provider, so that you're not running into the risk that internal IT resources might have access that they must not have. Right. So the second requirement on this slide we already touched, so protection of the identity of the whistleblower. This is something where we can always discuss about, is there a requirement for anonymous reporting? No, there is no strict requirement for anonymous reporting, but what we can say from more than 20 years of experience is clearly that anonymous reporting is absolute best practice. And there's a lot of studies available, a lot of information available that clearly shows that roughly half of the reports that are made through a whistleblowing system are made anonymously. And there's good reasons to guess that if you would not offer the option of anonymous reporting as an option, that you would probably miss out half of the reports that you could get. Right. Okay, so secure storage of data. This is something that we do. So as a provider like we, like us, runs high secure data centers, fully certified, extremely reliable, robust, and hardened, so that the information around the whistleblowing reports is really stored in a place that is as safe as can be. And this is clearly one requirement coming from the directive, and you're fulfilling it by using such a solution. GDPR compliance, this is something we should probably not go too deep into, but it's very clear. Yeah. So GDPR, this is something we are now speaking about for a few years. Clearly, any whistleblowing solution needs to be fully compliant with GDPR, and if you use a certified and independently certified system or channel like ours, this would give you sufficient guarantee that you're complying with GDPR. Then there is some deadlines, and this is the operational or the process-related requirements. So if a whistleblower files a report through the channel to your organization, then there's deadlines you have to keep in mind. So within 7 days, you have to acknowledge receipt of the report to the whistleblower, so that she or he knows it has been received, and it's best practice to give a short guess what the next steps will be, and maybe ask first questions back to the whistleblower, and then you also have to inform about the outcome with a deadline of 3 months if you have completed your investigation and handling of the reported case until then. So this is where a technical solution can also support you, because there is reminder functionalities that would notify you. Please keep in mind that within the next 10 days, you have to give feedback to the whistleblower and so on. You also have to make sure that you inform your organization and your stakeholders about the existence of the reporting channels. This is very clear in the directive, and the idea behind it is what would it do if you establish a reporting channel but you do not tell anybody? So if nobody knows that there is a secure channel he or she can use for reporting, then nobody will use it. And reporting should be encouraged, clearly encouraged, and so you have to inform and communicate about this. And part of this communication, and that's the last one on this slide here, is you're also obliged to provide information to your stakeholders, to your potential whistleblowers, on public reporting channels within the respective country, so the respective member state, because the whistleblower shall always have a choice between reporting internally to your organization or externally to a public reporting channel provided in the country. Clearly, we recommend, and this is a question a little bit about how you communicate your whistleblowing scheme, your whistleblowing channels. We would always recommend that you consider asking the whistleblower to report internal first, but you cannot make it mandatory. And the directive clearly does not allow to make it mandatory, so a choice should be given. All right, so this is kind of a quick overview on the core requirements. There are some details that we'll for sure touch in the next few minutes in the Q&A part of the webinar. So maybe back to Andy. Everything clear so far, or any immediate questions from your side? Anything that I forgot, but that's important?
No, thank you, Jens. We're getting a couple of questions coming in from the audience, so we'll get to those shortly. Just a reminder, you can enter questions into the questions tab that you'll see in your console. So I think that was a good explanation of the overall requirements of the directive, Jens. Could we look at how this specifically applies to whistleblowing systems? Because many companies will already have whistleblowing systems in place. Some won't have anything in place and will be looking at establishing systems for the first time, specifically to comply with the requirements of the directive. So what should organizations be reviewing or considering with regard to their existing systems or with the implementation of a new system? And what sort of questions should, for example, they be asking of their vendors?
Mm-hmm. Okay, so if we first look at organizations that already have a whistleblowing system in place, clearly our recommendation would be that you review it with a focus on maybe two main aspects. So the first one would be, do you cover within your whistleblowing system the option to clearly report breaches or misconduct related to EU legislation, or even if this has been broadened by one of the member states to other topics and national legislation within the member state. So do the categories that you allow reporting on cover what the directive requires? So this is clearly one thing you should look at. And the second thing is take a closer look at the processes that you've implemented. So who's receiving the reports? Who's investigating the reports? Have you made sure that you're matching the deadlines the directive is talking about? I said earlier, it's 7 days to confirm. It's 3 months to report to the whistleblower on kind of a final outcome. So review your processes to make sure that you're set up in the best possible way. And if you need support, if you need our expertise, because we are serving more than 2,000 clients across Europe, and we really have a lot of experience here in our customer success teams. So if you would want a sparring partner, want to challenge certain questions, please do not hesitate to get in touch and have the discussion with us. The second part of the question you raised, Andy, was I do not have a whistleblowing solution in place yet. So what should I do? Yeah, what do I need to do? Clearly, if you talk to a potential vendor, you need to make sure that you ask the right questions, and the right questions would be related to the core requirements we just looked at. Yeah. So what types of different reporting channels does the solution offer? Is it certified in terms of information, IT security, and not only the data center, but also the provider itself and the processes of the provider? Is it certified regarding GDPR compliance, so that you're not running into any huge risk because sensitive information is reported, but maybe becomes public because it's not secure, right? So this is something where we would put a lot of emphasis on. If you speak to potential vendors, and then also things like flexibility, especially for larger and more complex organizations that would probably have a number of different legal entities that are involved in the process, in the investigations, and so on. Yeah. But again, happy to support here, and we can recommend that you talk to our experts in the customer success team to consult you and take you by the hand.
Thank you, Jens. I'd like to turn to some questions we've got coming in. We've got about 5 or 6 minutes now, so let's get through some of the ones. So the first one, this comes up a lot. It came up in last week's webinar. It comes up in a lot of our discussions around the need to establish separate reporting channels. So the question is there a clear position as to whether each subsidiary with more than 50 workers is required to establish their own entity-level reporting channel instead of simply relying on a central corporate group? And the legislation adopted by Denmark appears to allow companies, even if they have more than 250 workers, to apply a central group reporting system, which appears to run contrary to the Commission's interpretation of the directive.
Yeah, that's maybe the mostly discussed question around the directive at the moment. So there is, what do we have? We have the wording of the directive. We have a number of questions that have been sent by different groups and stakeholders to the EU Commission, and we have some first answers from the Commission. And in addition, we have some perspectives from authorities and the political level in some of the member states. So it's quite a mix of information. And so what seems to be clear is that the Commission has a quite strict perspective, saying everybody would need a very own and fully independent whistleblowing system. And this goes against a lot of the best practice that has been built, how you establish and implement whistleblowing systems, especially in larger organizations over the past 20 years. So this discussion is still ongoing and it's not finalized. If you try to understand and interpret a little bit what the Commission is mostly looking at or trying to achieve, then you could think and could say, obviously they are trying to offer to a whistleblower the option to report to his local company, his local legal entity. And there might be an indication that the Commission also is looking for investigations to take place at the legal entity level. Does this make a lot of sense, and does this protect the whistleblower in the best possible way? For sure not. Because if you have a small entity, let's say there's 70 people, everybody knows each other, right? So how can you treat identity and keep the identity confidential or and protected of a whistleblower. So that's a problem. But this discussion is still ongoing. We'll see what the transposition in other countries will say, because as Andy said, Denmark seems to allow using the central organization. Other countries seem to follow the EU Commission's perspective. And for the time being, we would always recommend that you implement the system, or if you already have it implemented and it's structured in a centralized way, that you at least open it up slightly and, for example, include a question and a value list with legal entities, so that the whistleblower could say, I want this to make this report on behalf of this legal entity, so they could address within the existing system. Okay. And we would probably, just one final sentence, sorry. We would probably not recommend that you immediately consider and say, we have seen 7 legal entities, let's implement 7 new systems. Yeah, that's maybe too big.
Thanks, Jens. We've got a few other questions. I'll get through 2 or 3 of them, just relatively short answers. And then if we're not able to answer your question or answer it fully, we're happy to pick this up with you directly. Our North American site also has a web-based reporting system. Is this something that Europe and the UK site can use, or do we need an independent one? Short answer, Jens.
Yeah, short answer. In general, yes, you could use it. The question that I would raise here is clearly related to GDPR, because US software providers and GDPR compliance is a fundamental issue at the moment. So I would actually make sure that you take a close look from a data privacy perspective and include your internal experts on this evaluation. Yeah.
Thank you. Slip in two quick ones. Is the 3-month deadline for an update to the reporter or for final conclusion of the investigation?
It just depends on where you are with the investigation. So if you have finished the investigation and there's a final result, update the reporter on this. If you have not done, and you will not always be able to get it completed within 3 months, you at least have to give an update that should say, this is where we currently are, and this is what's going to come next.
Thank you, Jens. And we're up on time, but just one final one. Could I ask about the informing of the outcome element? What level of detail does it have to be? And there are concerns over confidentiality that could arise if I provide too much detail. Difficult one to answer quickly, but I'm going to ask you to.
I would say this is something for maybe the people where you get legal advice from, and we will only find out over time, right? Because some of you might be disclosing more information, more details to a reporter, others might do less. There will be court cases, and then we'll learn what this is about. I cannot answer it.
No. I guess we may come to this in some of the future webinars in this series, so hopefully people can join us for that. So we're out of time, unfortunately. I think we covered most of the questions that were asked. So I'd like to thank you, Jens, for your contribution for the discussion today, and thank everyone else for participating in the event, and also for the questions you've submitted. Just a reminder again that the third in this series of webinars is next Thursday, the 27th at 11 a.m. UK time. We'll be talking about choosing and implementing a new whistleblowing system, and we'll be joined by Rachel Pinkherd from Irish fintech company Fexco, who will be sharing the process that they recently went through and answering any questions. So you can register using the link on your screen now, or by going to your going to our website. So finally, just like to ask you to leave some feedback on today's event. These are really useful for us. If you could spare less than a minute to complete a very short survey, which you'll see on your screen now, this really helps us in informing the format and content of future events. So that's it for today. I hope you can join us next week. And in the meantime, I thank you again for joining and wish you all a pleasant day. Thanks, everyone.
Bye-bye. Thank you.